Tuesday and Thursday. Good morning, Tony Messenger.
Good morning, McGraw. Good morning, Kelly.
All right, so I find it interesting reading in your newspaper that Kim Gardner has been, quote-unquote, inundated with requests to release the full deal she made with the governor's office, and now I guess it sits with Josh Hawley to decide whether or not this happens?
Yeah, apparently, and this is, to Gardner's credit, she says she does not oppose the full release. Now, I go back and I question, how do you as a prosecutor, knowing what the open records law is, agree to something with blacked out, redacted information to begin with? I don't think she ever should have agreed to file a court document involving the governor with blacked out information. But now we have the situation where multiple news outlets, including the Post-Dispatch, have filed sunshine law requests saying, give us the unredacted document. And Gardner has said, fine. And the attorneys for Governor Greitens have said, nope, we don't want you to see it. And so now Attorney General Josh Hawley is going to have an opportunity to rule on it. And once again, Governor Greitens puts him in a box. He has to release it. He has to. This is the guy whose job it is to enforce sunshine law, to teach other public bodies about sunshine law. He has to issue an opinion now that says that document should not be redacted. There is no legal reason in the sunshine law or in the court of law that a defendant who's getting a charge drop should be allowed to file a stipulation that keeps part of that stipulation secret. And I suspect, because the governor's office is fighting it, that those two lines that are blacked out, or at least one of them, makes the governor look bad.
There's a million ways to go from here. What does the law say, right? Because why was it redacted? There's certain reasons why things are redacted: people's names, people's addresses, right? Personal information.
Yeah, there's things you can redact in court files, and there's things in the sunshine law that you can keep secret from the public for a variety of reasons, but it's personnel, it's real estate negotiation, personal contact information, things like that. There are times, obviously, during the process of this court trial that never happened, there have been documents that have been sealed in order to help ensure a fair trial. But now that there's no trial, those documents are unsealed, and it's very important that the judicial process is open. Keep in mind, the day after the governor resigned, I was in Jeff City, and there was a status conference between attorneys in the Confide lawsuit, and Judge Beadham, who's at the center of this thing in a variety of different ways, allowed myself and another reporter to sit in his chambers and listen on a conference call to this status report. Now, that doesn't happen very often because reporters don't often show up and say, hey, I want to listen to the status report phone call between attorneys. But Judge Beadham recognized this is a public body. This is a case of public interest, and I'm not going to shut people out. The same rules need to apply to the stipulation, and I believe ultimately that an unredacted version of that stipulation will make its way into the public eye. It's unfortunate that it's taking time and money and effort to keep it secret.
It's one of those things where we're only interested in it because we don't know what it is, right? I mean, it could be nothing, or it could be really very juicy.
It's probably not much, but it probably says something along the lines of, the governor who says he never did anything wrong admits that maybe he did something wrong.
Right.
I mean, it's probably something along those lines where it contradicts what the governor said during his resignation speech, or just what he has said and what his attorneys have maintained the entire time, that there's absolutely nothing to this case. Because if Kim Gardner didn't get some sort of an admission, and that's pretty disappointing as well.
Yeah.
And so that's just my best guess, having covered some of these things before. I covered a case years ago in Colorado in which there was a secret stipulation to make the thing go away, and we filed a sunshine law request and ultimately got it. I think that's what's going to happen in this case. I don't think the Attorney General should have had to have been involved. I think the judge should have ordered it open. But,
we'll wait and see what happens
eventually
there.
that will become open.
What do you make of hours before he's out of office, he's still fighting the Confide app disclosures, and then we find out that many more people use this secretive Confide app than we knew about when the Attorney General investigated?
Well, it gets to the bones of the whole story. This is a governor who had a lot to hide, and ultimately I think that's why he resigned, to try to keep as much of that stuff hidden as possible. And now it's interesting to see how both the legislative branch and the judicial branch, and to some degree the executive branch, because the governor's office is ultimately who's being sued in the Confide lawsuit, and Eric Greitens is no longer the governor. Mike Parson is. And so will the governor's office react a little bit differently to the course of that lawsuit? And what happens Thursday when the House request for a subpoena for dark records goes before Judge Beadham, even though the impeachment process has ended? There's a lot of public interest in this, in light being shined on these documents. Because what if something doesn't happen? What if we don't ever know what's in the redacted document? What if we don't ever know what's in the dark money account? What we have done then, as a body politic, as a government entity, both in the legislative branch, the judicial branch, and the executive branch, is we've said, well, that's okay. Well, the next guy can do it too. And unless he gets impeached and charged with a bunch of crimes, we're going to let that happen. That's what the Missouri political and judicial system is going to say if those documents don't ultimately get pursued and released. And that's why the public information is so important. Sunshine is a disinfectant. That's what people have said about sunshine law forever. If public officials have to do their business in public, they behave better. And that's why we have sunshine laws. And so taking this stuff to its full conclusion is important for the future of government in Missouri. It's not about beating up Eric Greitens anymore. He's not really even part of the story anymore. It's about protecting open government in Missouri.
Tony, point of question here. The investigation was a special session after the session had ended, but it was an impeachment session or an investigation into the governor. Does that go away? Can it still meet? What are the rules to this special session going on right now?
Well, they set a calendar. I mean, they've got 30 days, and they're still officially in session. Ultimately, the leaders of the House are going to decide, okay, what do we do with this? Is it appropriate to continue an investigation into the governor's office even after the governor has resigned? They'll no longer be impeaching him. They could, post resignation, still issue, for instance, a censure or something, so that there is a record that the House disapproved of this governor's performance in office. I mean, they could continue. I believe that, at least as it relates to unearthing the documents and what they were investigating and making public much of what they did in secret, I think there is value in this House committee continuing to some degree, not just going away because it's politically expedient. But will they? I don't know. I think we'll know in the next week or two.
Tony Messenger, have a good day. We'll talk to you Thursday.